Houston, Texas. Along with me is my business partner, Emily Newman. We are partners in Reddy & Newman PC. Our law firm has been established in 1997. Emily?
Hi, thanks for joining today. At Reddy & Newman PC, our goal is to make complex immigration simple. So we're here every week to answer your questions and provide you with the latest updates. And you can always find us on rnlawgroup.com is our website, as well as Reddy & Newman's Facebook page. And you can find me at immigrationgirl.com, as well as on Twitter at immigrationgirl, or on Facebook at immigrationgirl. So we have lots of topics going on today.
Yeah, too many topics going on. I hope you liked our videos. If you like, please make sure that you like or subscribe to our channel so that you get the weekly updates. And also, Emily and I have decided that we're going to update you on each topic separately. Every week, maybe one or two different topics. And this Thursday, we're going to have live session at 5 o'clock exclusively on STEM extension people working at third-party site. Emily, what is going on the RFEs of the H-1B? Are we going to have an RFEs going forward after September 11th? As you know that, Emily, that September 11th, the USCIS issued a memo that they could deny the non-immigrant visas or any kind of immigrant applications without issuing an RFE. Are they going to do it, or are they going to still issue an RFE?
Yeah, that memo is absolutely taking effect next month on September 11th, but the actual impact of it, in my opinion, should be relatively low. I think that the memo is geared towards, there are people that will file applications just completely incorrectly, not knowing what they're doing, and I think the goal is to avoid having to send requests for evidence on things like that, not so much as prohibit valid, legitimate employers from filing for their employees and making it more difficult for them. So yes, it is something to be careful of and make sure that all of the required initial evidence is being submitted after September 11th, but I don't think it will affect the majority of people who are on high-skilled visas.
So what are the essential documents for these high-skilled visa people? What is the essential documents that the regulations have prescribed, the law has prescribed, or the forms have prescribed, and which are absolutely essential when we are filing the high-skilled worker employees?
Yeah, I mean, it's going to be different for every type of visa. Typically, you would look to the instructions of the application form. Those are available on USCIS website, but it's the basics. Like for an H-1B, you have to submit all of the required I-129 forms. You have to submit the certified LCA, education documents. They do specify that they want the education evaluation to be submitted. That is required initial evidence for those that have a foreign degree, so that might be a little bit of a change. If the job requires a license, they want to see the license at the time of filing. They're not going to send potentially a request for evidence for the license later on. And then if you're requesting an extension of stay or a change of status, they want to see your previous status documentation, which would be pay stubs, potentially W-2. So it's pretty basic documentation. That's going to be your required initial evidence. Depending on the situation, if an itinerary is required, then the itinerary probably would count as required initial evidence.
Emily, what are the trends that are going on in the non-immigrant visa section for the high-skilled people? We are noticing that as compared to in 2016, a lot of RFEs, a lot more denials according to the statistics, and also as a practitioners, we see that. What are the trends that you're noticing in the RFEs and the denials?
Yeah, everything's definitely gotten harder, not easier for sure. The standard that you have to meet to get an approval now versus 2 years ago has changed quite a bit, even though regulations really haven't changed. It's requiring a lot more explanation and documentation to get the same approval compared to what it was 2 years ago. And also kind of a new trend that we're seeing at the consulates related to the Buy American, Hire American executive order, especially in the L-1B visa interviews, E-visas. A lot of times the consular officers are asking why can't an American do your job? Or tell us what's so special about you that we need to bring you into the U.S. instead of hiring an American worker. I've not heard of people being denied the visa based on answers to those questions, but it is something you should be prepared to answer if you're going for stamping anytime soon. Other trends we're seeing in requests for evidence, I don't think much has really changed over the last couple of years. Still, the common ones are specialty occupation for H-1B, specialized knowledge for L-1B. You've really got to prove what is special about this person, how they're different from other people in the same job within your company, within the industry. I think that it's just more difficult to get approvals. It's not impossible, but it's a higher standard.
We recommend people who are filing for their non-immigrant visas to file their visas way early so that the results can be obtained before their I-94 expires. If they are filing for an extension, if they file an extension way before their I-94 expires, they might have a lot of different options though. So if you file an extension for either L visa, H visa, or any other non-immigrant visa, you get the denial, you could file potentially one more extension. If you're transferring to a different company and then you get the denial, your I-94 validity is still there, you might have different options to file one more time with the same company or probably to move a different company. You might want to consult a lawyer when the change of employer has been denied. However, you will have more options if your I-94 validity is there. If the I-94 validity is expired, your options will be very limited. In most circumstances, you might have to leave the country. So be watchful about the I-94 expiration. Try to get the result as early as possible. That's one step that I would require you to do it. And if you are filing for any non-immigrant visa documentation, if you can collect as much documentation as possible way early at the time of filing the application, you might be able to avoid the RFE, which delays your application process, that might let your I-94 expire. So if you have any necessary documents that need to be submitted, it's better to submit it. Now, if you are contemplating joining a particular company and you are not going to get the documents as what the lawyers want, which most probably you already know what documents are required, where if that particular company or that particular position does not provide all the documents that is required, I would probably choose to join some other company that will provide all the documentation early. If you have that option, we would strongly recommend that you avoid the positions where you're not getting all the documents very in advance, and try to join those organizations where you're going to get all the positions.
Yeah, it really is essential these days that the company strongly support the application that they're filing. So if the company is really not supporting you and getting the documents you need for a successful petition, you may want to consider joining another company instead that is supporting you in that application. One question that came up from Chandra, what do you do when you get a specialty occupation RFE? Is anyone getting an approval when the specialty occupation issue comes up?
Yeah, obviously people are getting the approvals in the specialty occupation. Specialty occupation is an absolute necessity to prove that to get the H-1Bs. In the specialty occupation, where the position must require a specific degree as a minimum requirement. And those have become very tough compared to what it was in 2016. If the position requires a couple of different alternative degrees, that is becoming a big problem nowadays to get the H-1B approval. If the position requires a specific degree, then it will become easier for getting the H-1B approval. When the specialty occupation RFE has been issued, you have to take it with caution. You have to make sure that all documentation is provided. If there is any position documentation that you needed, either from your company or in certain situations you might need an expert evaluation, or a third-party company might have to provide certain document information. You need all the language to be in a proper, probably what the lawyers will wording if the position does not reflect those things, you may have a problem in getting the specialty occupation. Emily, is it worth to doing the evaluation, specialty occupation evaluation done by a professor when the specialty occupation RFE has been issued?
I think there are certain cases where it can be helpful. You have to kind of look at the overall strength of the case, and if you have a strong SOC code where the Occupational Outlook Handbook has good language, or you have prior job postings that your company has publicly posted to try to recruit workers that give the education requirements for the job, those can be extremely helpful. If you have competitors in your same industry that hire the same type of employees, if those competitors issue a letter stating that the job normally requires a degree in this specific field, then you may not so much need an expert opinion to go with it. Now, if you have less of that evidence or it's not as strong, then an expert opinion letter might be more necessary to get the approval. That being said, even with the expert opinion letter, even if it's a good one, it doesn't guarantee approval. So it can help make a case stronger, but certainly there's no requirement that USCIS follow what's in that expert letter.
Srikanth has a good question, Emily, is that on what basis the extension duration is being determined? As we have noticed, Emily, that some of the H1B, some of the extensions are coming for a very short period of time. In some issues where we are getting the approval in August of 2018, but the approval is only until March of 2018, this case might have been filed in December of 2017. So even on what basis they're giving approvals for 3 months, 6 months, 1 year, and 3 years? What is the basis for determination for the duration?
Yeah, I think the majority of the cases where we're seeing a shorter duration, it's based on the contracts between all of the companies. You know, it's a situation where it's a consulting placement arrangement, and maybe the end client letter gives a specific date for when this project will end. Even if it mentions that we plan to extend it or extensions are likely, if you have a date there, you have a shorter date in a work order perhaps, USCIS officers tend to go with the shortest date possible rather than the longest date possible. So it's important that to time the filing of your petition based on when you have the longest validity of that work order and that client documentation, and make sure that the types of projects that are being selected to sponsor someone for should be more longer term projects. It shouldn't be a 3-month project. Now, I understand budgets at client companies can require work orders to be issued in shorter durations, but if you have a kind of a pattern showing that you've always received these extensions and you can show that in the past it's been extended, then maybe you have a better chance of getting a longer term approval.
Either way, it's advisable to do the premium processing to get the result earlier, because in issues where the non-immigrant visa has been filed in 2017 and the request was made probably until 2020, they only got the approval until March of 2018, and the results came in August of 2018, and they're doomed. If they would have got the results way early, Emily, things have been quite different. If they would have got the result in February of 2018, the results would have been quite different. They can file one more extension based on a different documentation. They would get it from different places. So that is becoming a problem. And one of the reasons why, Emily, a lot of these people are not filing premium processing is that there is a presumption that they say that if you file a premium processing, you are sure to get an RFE. You're sure to get the denial. Is there any truth to that?
Yeah, I completely disagree with that. We file lots of our petitions in premium processing, and I think that the rate of requests for evidence is the same between premium and regular. The rate of denial is going to be the same. The benefit of premium processing is certainly you get the faster results, so that you're much more likely to have, if there's a negative result, it happens before it becomes a big issue, meaning before your I-94 expired, because you've used that fast processing. But it also has some additional kind of customer service aspects to it that can be extremely helpful, and we've had to use quite a bit lately, where you end up with an approval notice that has incorrect dates on it or a typo or something, rather than going through the long route of an e-request or service request with USCIS regular customer service. Employers and attorneys can instead email the premium processing unit, and they're much quicker in responding and can get that corrected notice out to you just within a few days usually. So I definitely prefer that higher level of customer service that we get through premium processing, in addition to the faster response time, in order to ensure that we get the notice and we get the decision before someone's I-94 expires.
There's some people asking questions. Srini is asking a question: how long it's taking to get the H4 and EAD? If you're asking for H4 and EAD together as a separate application, not including in the H1B application, it might take anywhere between 6 months to about 12 months. And if it's just an EAD application, it's taking approximately 100 days. And if you file for the H4 plus EAD along with the H1B, normally it will be adjudicated along with your H1B application.
Ayush has a question. If say you're on F1 and you filed your change of status to H1B, and maybe the petition gets denied, not for anything related to the F1, but maybe specialty occupation couldn't be established, or the beneficiary qualifications didn't match up with the job. What is the long-term impact of that denial? Is the person going to be able to try again next year? Is there going to be any kind of negative consequence just because they've had that one denial?
If the denial is not based, as you said, Emily, it's not based on the status violation, that will not have any impact whatsoever at all on this particular person. He could file a H1B application the next year, and just because he had a denial previously will not have any negative implications. Emily, I want to go back to some of the questions that are popping up here, and then we did present the Thursday just about on exclusively on the August 9th memo, which has changed the definition of how the unlawful presence of the students has been determined. Previously, it was determined based on when the denial comes from there, it will go. However, the USCIS August 9th memo says that it is going to go back to the date when the violation occurred, or August 9th. Now, in light of that, we have also noticed that there are universities that are issuing day one CPTs. They are not even conducting classes, not even once a month. Some of them are conducting once a semester. And these students are joining the universities not for the purpose of studying, because it's mostly the second master's degree in the same relevant field that they had before. Can the day one CPT cause a problem, a long-term problem for the students that are doing it based on the August 9th memo? And if so, what are the effects of it?
Yeah, I think it definitely can. We've seen cases over the last 2 years where USCIS has really scrutinized use of CPT. I think there are two main issues that come up with CPT. Number one, the basic regulation on CPT says that you can be eligible for CPT after you've completed at least 1 year of your graduate studies. But these people are getting CPT immediately as soon as they join the school. That's based on an exception to that regulation that says if your particular program requires immediate participation in this CPT for all of their students, then you can get CPT prior to the 1 year. Now, USCIS is heavily scrutinizing whether that program really does require immediate participation, or is it just a way for students to be able to work and study on the side, which is not the purpose of the F1 visa. So that's one issue with F1, is if the school cannot prove that immediate participation is required of all students in that program, USCIS will come back and say that that CPT program was not properly authorized. Now, prior to this year, that would be it, end of story. You would get a change of status denial, you'd exit the country, go for a visa stamp, come back, everything would be fine. Now, when they say that CPT was not properly authorized, that goes on to say that it's a violation of status. Now, a violation of F1 status that's determined by USCIS means that unlawful presence begins from the day the violation began, not the day the decision came in. So if you've been using CPT for a year, by next summer, for example, and you get this type of request for evidence and the USCIS determines that the CPT was not properly authorized, they're going to say you've been violating your status for the last year, therefore you've been unlawfully present for the last year. That means when you exit the country, you're going to trigger a 3 to 10 year bar to you being able to come back into the country, all because you wanted to stay and work for a couple of extra months. The short-term gain of being able to work for a temporary period is majorly outweighed by the long-term consequence of potentially being barred for 10 years from this country. So that's one issue. On top of that, we have the NTA memo, which that memo is on hold right now, but it very likely will be put in place anytime in the near future. That memo says that at the time of a denial, if you are unlawfully present, USCIS will issue an NTA, meaning a notice to appear in deportation proceedings. So not only are you accruing a year of unlawful presence, triggering the 3 or 10 year bar, now you're stuck in deportation proceedings on top of all of that, just for the benefit of being able to work for a little while longer. That's issue number one with CPT. The issue number two is the regulation specifically says that once you've used 12 months of OPT, you're not eligible for additional practical training unless you go up a degree level. So those that are doing this second master's have not gone up a degree level, yet they're still being granted this CPT after they've used all their OPT time. Now I will say, over 2 years ago, the interpretation of that regulation was different. Everyone agreed that you could get CPT without going up a degree level. But that's not what the actual regulation says. It doesn't specify anything between CPT or OPT. It just says all practical training is not allowed unless you go up a degree level after you've finished your OPT at the lower degree level. And we've yet to be successful arguing that type of case, which means those that tried that argument ended up with a change of status denial, ended up with a determination that they violated their F1 status. Now with the unlawful presence memo, that means unlawful presence began the day they started the CPT. And again, once the NTA memo is in place, they're going to get an NTA. So that's a lot of risk you're taking just to be able to stay and work a little bit longer.
I think so. That answers the questions Krissa was asking, was that can I get an OPT for the second master's degree? Emily already did answer, no, you cannot get the OPT again for the same level of degree. Now I want to address what Bharat is asking, and I want to extend that a little bit more, Emily. The perm filing, how does it affect the 7th year extension? I want to address all issues, how people can do 7th year extension, taking an opportunity of Bharat is asking. So if the perm is filed, and if it's less than 1 year the perm is filed, as Bharat did not specify, but if it's less than 1 year, can you extend the H-1B beyond the 6 years?
No, not unless your perm is approved within that 1 year and the I-140 is also approved.
So if the perm is approved and the I-140 is approved, it doesn't matter when you file the perm. If you have the I-140 approval, you can extend the H-1B beyond the 6 years. Now, if the perm is pending because of an audit for more than 1 year, could you file an extension of the H-1B beyond 6 years?
Yeah, I think you're definitely eligible for that 7th year extension in that situation, and as long as you have proof of the filing date of the perm, it should be relatively straightforward.
If the perm is denied, if it's an appeal process, can you file, and it's more than 1 year that the perm has been filed, can you file a H-1B extension beyond?
Yeah, basically until a final decision is issued on that perm, and a final decision has not been issued yet if it's up on appeal. So an appeal keeps the process going and allows you to continue extending the H-1 in 1 year increments as long as that appeal is pending, which right now with BALCA processing times at 4 or 5 years, you're likely to be able to get a couple of H-1 extensions based on that.
If the person's I-140 is approved and it's been more than 180 days that the I-140 has been approved, can he use the I-140 approval of company A, and can he file a H-1B extension beyond 6 years with company B?
Yeah, definitely. No restrictions on that since the January 17th, 2017 regulation. That has been allowed in very clear guidance that you can do that. You can file those extensions with any company. It doesn't have to be with the company that filed the I-140.
What if the company A has withdrawn the I-140 after 180 days? And can company B file the H-1B extension beyond 6 years?
Yeah, also thanks to the January 2017 regulation, even if it's the I-140 is withdrawn, as long as it was approved for 180 days before the withdrawal happens, you can still get those H-1 extensions with any company based on a withdrawn approved I-140.
Can he move to company C with company A's I-140 approval for more than 180 days, even though company B did not file the labor certification?
Absolutely. You can move to B, C, D, E, all the way to Z if you wanted to.
Can he get the prior to date ported if it's more than 180 days that the I-140 has been approved, and he moves to company B and company C files the labor and I-140?
Yep, you can get that same priority date on the new I-140.
That's good. I mean, we have some good news, but I just want to caution the people that if the I-140 has been approved for less than 180 days, and if you want to leave the company and you want to move to company B, the company A can still withdraw the I-140, and then you cannot file the H-1B extension. If they withdraw it after 180 days, then it will have no impact whatsoever at all. As Emily has stated, that you can use the same I-140 for company B, you can use the same I-140 for company C, you can go on. You can even go back to your home country, and you can always resurrect your H-1B at any point of time if you have that I-140 approved, and it's been approved for more than 180 days.
So you're saying even if you've been outside the U.S. for over a year,
yes,
you can still get an H-1B without going through the lottery again?
That is right. Even though you completed your 6 years, you leave the country, you stay in your home country for more than 10 years, you can resurrect your H-1B without subject to the cap.
Yeah.
So that's an advantage that you get it with the I-140 approval. So it's essential. But in cases, there are a little bit controversial cases, is that where the perm has been filed and it's been pending for 9 months, okay? Can we file the extension when the H-1B is expiring in 4 months? That means that by the time H-1B expires, it's going to be 12 months that the perm will be pending.
Yes, as long as on the start date you're requesting on the H-1B meets the 365-day requirement, then yes, that should be allowed.
Emily, with regards to the green card processing right now, what's going on in the green card processing? All of a sudden the dates have moved back. Can you explain what's going on in the September visa bulletin?
Yeah, not only have they gone back, they're completely unavailable, even though the visa bulletin shows that certain people could file. So they have 100% across the board run out of this year's green cards. There will not be any more issued in the employment-based categories until October 1st. So typically, over the year, the State Department and USCIS slowly approves the green card applications for those that are pending, and they slowly move the priority dates forward to keep the supply and demand relatively even, so that by the end of the year on September 30th, they will have used up that last green card, and then the next year's green cards become available on October 1st. This year, we know we already have seen the September visa bulletin, which retrogresses all the priority dates backwards, meaning that people who were eligible to file in August, if they don't file in August, they won't be able to file in September. But on top of that, those that are already pending that have a current priority date in August and September, even if everything is ready to go, they've already been interviewed, they're being told at the end of the interview, sorry, we're out of green cards, we can't approve your case until after the new fiscal year begins. So unfortunately, more green cards were issued at a faster rate this year, so they ran out too soon, and that is what caused the retrogression. But on top of that, we have complete unavailability. That being said, if your priority date in the September bulletin or even in the August bulletin is current, you can still file the 485. The issue is just that they won't approve the 485s that are pending for those that are actually current in those 2 months because they don't have the availability.
Palni and Rajesh, both of them have the same question on whether the STEM extension OPT person can work at third-party site. And there are also a couple of other questions coming on it, whether when the RFE has been issued on the STEM extension, what needs to be done. We might give a brief description right now. There are not clear answers what should be done, what should not be done. But I would recommend that you guys log into Facebook. On Thursday, we're going to have exclusive session just addressing the STEM extension OPT only. In this general Facebook Live right now we are unable to cover that topic extensively, but on Thursday we're going to cover the STEM extension part only. All the things related to STEM extension, you can pose your question there. We are going to answer those questions. But in short, should they stop working? Because the Department of Homeland Security website in its PowerPoint presentation says you can work at third-party site. It's clearly on page number 22, but the USCIS quietly updated the website saying you cannot work. Now, is there a clear answer from you, Emily?
No, not until I have an approval or a denial. I can't give a 100% clear answer. But I do think that in the presentation from ICE, which is the agency actually responsible for administering the F1 students in the OPT program, they say back in 2016 that remote or distance employment is permissible. At the same time, in that same presentation, one slide earlier, they say that staffing agencies and temp agencies may not sign the 983 form. It has to be the actual customer site where the person is working that signs the 983, and that employer has to be the E-Verify employer. So we have off-site and distance or remote is okay. They don't use the word third-party placement. They don't use the word consulting. They say staffing and temp is not okay. And now we have the USCIS website referring to third-party placement saying off-site is absolutely not okay. So it is very confusing, completely different interpretations of the exact same regulation by two agencies under the same umbrella, Homeland Security. What we do know is USCIS is questioning those that are working, that from the documentation they can see they're working at a third-party site while they're on the STEM OPT, and they're requesting a list of documents stating that we don't think this is allowed. They're not giving you the, they're not saying how you can overcome the request for evidence in the request. They're just asking for a bunch of documents, which to me means their ultimate goal is to deny the change of status. My thoughts on it are, it's USCIS officers are the ones adjudicating this application, not ICE, meaning that USCIS...
Which they are. It's not ICE which is adjudicating anyway.
And so I think that it would be very surprising for, even if you make all of the arguments you can make that this is, a regulatory update that was done by website and it's against the regulations, it doesn't match what ICE said, you make all of those arguments, the officer that's actually adjudicating your application is going to say, yeah, but our website says this, so I have to go with what the website says and I'm going to deny your change of status. So for that reason, I think in the majority of the cases, we're talking one-on-one with each client that's in this situation and has this request for evidence, but in many of them we're requesting or recommending that they convert their application to request consular processing instead of the change of status. The hope is that we can avoid a determination that a violation of status occurred, which avoids unlawful presence, which avoids an NTA. Then you get the H-1B approval, exit the country, no unlawful presence, no 3-year bar, you get the visa stamped and come back.
And then we have to be watchful about the August 9th memo with the violation of status. So if you could get the result before February 4th, that would be very good for you. You may want to consult with a lawyer when you get an RFE on the STEM extension part, because as Emily was pointing out, there are different strategies where you can dodge the question by going to the consular processing. But a more detailed description of those things, we're going to present it on Thursday, because it's going to be exclusively on STEM extension part only.
One of the questions has to do with passport validity. So in the particular question, they're getting ready to file an amendment and their passport's expiring. Is that going to have an issue?
If the application, at the time of filing the application, if the passport is valid, then they don't have any problem in getting their non-immigrant visa adjudicated. But if it's expired and they file an application with the expired passport, they will have an issue.
Yeah. Now, another area where the expired passport or expiring passport comes into play that a lot of people never realize is when you're traveling. So, for example, if you have your visa stamp and your approval notice that's valid for 3 years, but your passport is expiring next year, when you're traveling into the United States, the CBP officer is going to give you an I-94 end date matching your passport, not your approval notice. And so many people never realize it. They assume that when they enter, they're going to get the I-94 valid to match the approval notice. But the officers do cut it short when your passport is expiring before your petition is expiring. You have to go online to the CBP website and check your I-94 as soon as you can after you enter the country to see what date is given. And if you do get that shortened end date, once you have your passport renewed, you have a couple of options. You can exit the country again and come back with your new passport to get the full validity period. You could file an extension with USCIS, but from the passport expiration date going forward for a new extension. Those are going to be your main options. But doing nothing or not realizing that it expired is going to be a big problem for you, especially in the age of unlawful presence and NTAs. That's going to be a big risk.
August 9th memo is also to be careful. And please be watchful of those status questions that are arising in the H-1Bs. Our L1s and other visas, though, is that it's better to get the decision as soon as possible, particularly for the student visa people. Now, in light of the August 9th memo, it's better that you get the decision before February 4th of 2019, because if you get it afterwards, you might be in big trouble. We want you to watch our video that we presented last Thursday. It's available on Facebook and also YouTube. Please watch those things if you want to study about how the August 9th memo is going to affect you.
Do we have any updates on the H-4 EAD?
Well, none. That's good. None is always better. H-4 EAD is still active. You can still file the H-4 EAD. You can still file the H-4 EAD extension if you are eligible for. No problem with it. Even though we were expecting some proposed regulations to be coming up in June, but it's August right now, almost August, middle of August, and we don't have it. I hope we don't get any updates on the H-4 EAD soon. Question came in, what do you think of the HR 392 prospects? As all of you guys might be aware that HR 392 takes a per country limit off, giving equal chance to all the people to get the green card, and if that passes, it's going to make the priority dates for Chinese and Indian nationals very forward. What are the probabilities of HR 392 to pass through, Emily, right now?
I think it's based on all of the different amendments that were added to the spending bill during the committee. We have to get all of those, it's going to go through several other committees where more amendments are going to be added on. Then we've got to get it into the House. I think a lot of the pro-immigration amendments that were added during the committee, which are great, may not survive when it goes for full debate in the House. Then we have to get the Senate on board with all of that. So I would love to see it be added in the bill, but it's just really hard to guess right now if it will. It's definitely got a long road to go before it makes it into the final bill and gets signed by Trump.
Ashwin has a question that you raised, that if an American can do the job, if the consular asks the question, what should be the answer? It's not just the answer for that. In general, you need to consult a lawyer before you go to the consulate, though. I would, normally when I speak with the clients, I can't provide an answer because I don't know the position. I would normally speak with the client to see what they say and then advise them accordingly whether that is an appropriate fit or maybe it's not an appropriate fit. And then I will let them make a decision what they're going to answer. But I can't give them the answer because that's a specific question. But be careful when you're going to the consulate. Nowadays, we're seeing a lot of 221G issues and a lot of 221G issues on H4 visas nowadays. That's very surprising that the H1 person is already working, but H4s are getting. In general, going to the consulate right now is not advised unless it is a must that you take that option. Please try to avoid to go to the consulate unless it's a must. If you're going for a consular processing, you're in a different country and somebody files H1B, you don't have an option. You have to go to the consulate. You can't jump the wall. Of course, you have to go to the consulate. So that's fine. But if you are in the country and you got the change of status approved or your extension of status approved, please try to avoid the trips going to your home country. And if you're going for stamping to your home country for a business immigration visa, if you think so that the Trump administration and Jeff Sessions likes you to come back, well, it's up to you guys. But I know what they wanted. So please be careful if you're making a trip. One other advice is that a lot of people, when they get stuck, they ask, what do I do about my house? What do I do about my car? If you are going there, I would tell you, just sell everything out, please. I mean, sell everything out and go there. If you get the visa, come back. If not, settle down. That's all my recommendation is.
All right. Where did I have one other question? What happens if you're on H-1B and you lose your job? What options do you have?
Well, good thing was that the new regulations that came out in January 17th of 2017 allows you to stay in this country for 60 days without a job after you lose the job. However, your I-94 should be valid. If your I-94 is not valid, that 60-day period is not there. In that 60-day period, you are allowed to find another job, to find file another H-1B. If you are eligible for H-4 visa, you might want to consider changing to H-4 visa, but not the F-1 visa. The reason you cannot get the F-1 visa is, Emily, it's taking approximately 12 months to 18 months for the people to get the F-1 visa. They are supposed to maintain the status until about 30 days before they get the F-1 visa. So you cannot go to F-1 visa. If you're eligible for H-4, that's good. If you get another job, you can file a H-1B. But please note that your I-94 validity is there. If the I-94 validity is over, you lost the job, you have to leave the country. You don't have much options.
All right. Any other questions?
A lot of questions are coming up on the third-party placement on the STEM OPT. We are aware of it. We are aware of the litigation, which we were a part of reviewing the litigation. We are well aware of what is going on it. There are certain times not clear answers, but we're going to address it very clearly on Thursday. We're not going to discuss about anything else other than the STEM extension working at the third party. Please tune in for the Thursday, and also you can check our thing on the YouTube too. Anything in them?
All right, I think that's about it for today. Thanks for joining us. Remember, if we didn't get to your question or if you have specific questions on your case, you can always schedule a consultation with either of us or any of our partners or other attorneys at our office by going to rnlawgroup.com. Feel free to share with your friends, us on Facebook, Reddy and Newman PC, or Immigration Girl, and visit my blog, immigrationgirl.com as well.
Thank you for patronizing Reddy and Newman PC. Thank you very much, guys, for coming in.